The next case to come before the court today is in Ray J.S. Attorney Neil Agarwal representing the appellant in this matter, and Attorney Jacqueline Corrigan representing Summit County Children's Services. Please note that we will not say the names of children or victims in your argument. And please stay behind the podium as we are recording this. You will have 15 minutes, Mr. Agarwal, to present your case, and you may reserve up to 5 minutes for rebuttal. Please let me know how much you'd like to reserve so that I can keep the time accordingly.
I'll reserve 5 minutes.
Okay, and I assure you that the judges have read your briefs, and we are ready to proceed when you are.
Thank you. May it please the court. Attorney Neil Agarwal, representing the mother in this case. Your Honor, the facts of this case are really easy. Children's Services filed a complaint alleging abuse, dependency, and neglect on 3 children. There was a finding of dependency for this particular child. Months later, Children's Services files a motion for permanent custody. There was a hearing for that. Mother, at the start of the hearing, through her counsel, voluntarily relinquished her parental right, or did a waiver of her parental rights, and we're not in any way suggesting it was not knowingly, intelligently, voluntarily done. The judge did it by the book, went through the rights, the forms, it was all done. The father contested permanent custody, and at the conclusion, the trial court overruled the agency's motion for permanent custody and granted a 6-month extension to give father additional time to comply with the case plan, finding that with the 6-month extension, there's a substantial likelihood of reunification with the child or a substantial finalization of a dispositional for the child. In the same journal entry, though, the trial court did not, well, granted, I don't want to say granted, but terminated mother's parental rights to the child and said she's no longer a party to the litigation. And it's on that basis, and basically that basis alone, that we're here for today. I'm arguing that there's no such thing under Ohio law that allows the trial court to terminate one parent's parental rights, but allow the other parent to continue for reunification. There's no statute, there's no case law, there's no rule of juvenile procedure that I've been made aware of, nor has the state cited, that allows a court to terminate only one parent's parental rights. And I'm saying a court cannot split the baby. Either the court grants permanent custody and terminates both parental rights, or it denies permanent custody, and neither parent's parental rights have been terminated. Now, if father regains legal custody, or even a relative, or someone else, let's say permanent custody is not granted in a final disposition, mom still has, or would have, residual parental rights. The right of visitation, a right to pay child support, the rights contained under 2151 and 353. What happens to those rights in this situation where mom's parental rights are hereby terminated and she's no longer a party? I'm arguing that would be inconsistent. She would not have any residual parental rights. And the state does not address that argument. They don't even question if that's accurate or not, that she would have none. If the father got legal custody, he would have a right to demand child support from the mother, or a relative. Somebody gets legal custody. Mom would have not only a right, but she really has an obligation to also support the child, whether it's through an order of the juvenile court or through CSEA. But that's something that the party who has legal custody can rely on for financial support, and she wouldn't have to. Now, that would be great for this situation, but I will tell you, if this court upholds the trial court's decision, I represent a number of parties at juvenile court, especially, I hate to say it, but deadbeat fathers. And these men come to me all the time and say, when a case starts, look, I don't want anything to do with this case. I don't want anything to do with the kid. I don't want to do anything with the mother. I don't want to do anything with children's services. I don't want to be involved in case plan. I just want to sign over my parental rights. And I always tell them, that's not a thing. You cannot terminate your parental rights while mom is working her case plan and trying to regain unification. However, if this court says what the trial court did is fine and it's not reversible error, so be it. I can then file on behalf of my clients the very next day a number of pleadings to terminate my client's parental rights.
But counsel, I was going to say, you make some interesting arguments here, and I understand your point, and I think about all the cases I've sat on where they've exactly done what you say they can't do.
Well, I have found no case law, and again, there's none cited that allows that to happen. And I guess that...
But what I'm saying, in practicality, that happens all the time.
I'm not aware one way or the other, Your Honor. So, I mean, I want to say it's a matter of first impression, not only in this court, but anywhere. Legally, can it be done? I mean, we always know things can be done if no one challenges it, I guess, and it just goes by the wayside. But as a matter of law, can the trial court do this? Can the trial court bastardize the child by terminating one person's parental rights and saying that child no longer has two parents under the eyes of the law? It would only have one.
How does that bastardize a child?
Because
I couldn't get that argument, I'm being honest.
a child has two parents in a legal sense. If the court terminates one parent's rights, that child from there on out will only have one parent. And I'm arguing that'd be like a mother giving birth with an unknown dad. And I'm using that in the sense that that's...
But the birth certificate, it's just not the same thing, is it? I mean, otherwise, if somebody just died, would the child be bastardized?
No, I wouldn't say that. But I'm saying in this case, legal. I don't mean in a moral sense or in a biological sense. I mean in a legal sense, the child only has one parent that's legally recognized while the other one is still out there. Again, this man, or in this case a woman, is out and about, and again, what is to stop any father to just have parent-child with as many women as he wants, and any time the child, there's a case, he just says, oh, you know what, I'm done. I don't want to be involved. I'll sign over my parental rights, and then mom and the child can, work with children's services, and there's absolutely nothing that would stop that. It would also force, I think it would increase taxpayer funds for these unwed mothers or people struggling who need welfare or financial benefits, food stamps, and they cannot rely on the other parent for financial support no matter how rich or well off they are, because they're no longer a party. They no longer have any parental rights to this child. And again, what is CSB's argument to that? They don't address it. They ignored it. They just said, well, mom doesn't have standing to raise the child support issue, so what does it matter? But as a matter of policy, I think this court would be very concerned about the court just terminating one person's parental rights while the other person's trying to work the case plan.
Counsel, if the court had just accepted the waiver, but not made the finding, would the order be final?
If the court did not terminate mother's parental rights, it would not be a final appealable order. I don't think so, because the case is not ended. But here, the case is ended as far as mom is concerned. She would have no standing, and the court says she has no, she's no longer a party. So, and the state's not arguing she doesn't have standing at this moment to raise, because her parental rights are implicated, and she wouldn't be involved for the next umpteen number of months of whatever happens to this child. She can't attend hearings or counsel. She can't participate in any future legal custody motions or permanent custody motions. She's an outsider. She won't get pleadings. She won't get notices. She's not able to appeal at the end. I mean, this is her time to appeal. Either she does it now, or as Justice Carr said, I guess it'll just go by the wayside and nobody will appeal, and that would be it. So I would ask this court to reverse the trial court and decide that if you grant permanent, and again, I have to say there was no granting of permanent custody. The trial court specifically denied the motion. It says overruled. So then on what basis did the trial court act in terminating mother's parental rights? And I can't think of any statute or law that says anybody can just come into court and say, Your Honor, I know you're denying permanent custody, but I still want my client's parental rights terminated. And the court can say, sure, no problem, done.
Counsel, are we going to find in the record, either in the written waiver form or in the colloquy with the trial court, evidence that the mother was only waiving her right to a contested hearing on CSB's motion for custody that was sort of clarified by either the written form or the colloquy?
I don't think so. I mean, usually the procedure is, there's a motion for permanent custody, and mom comes in, or the dad, whatever, the party comes and say, I want to I don't want to contest permanent custody. I'm in agreement with it. Here's the waiver form. The judge, very diligently, she goes over the waiver form, saying, you will no longer be a party, you will have no rights and obligations, you'll be done. And that's what the judge did here. But I don't know if it was contingent on, I don't think the record says one way or the other. I can't recall anything like that. Right. Thank you. And I'll let you reserve the balance of my, thank you.
You'll have 5 minutes on rebuttal.
Thank you.
You may proceed.
Thank you, Your Honor. Good morning, and may it please the court, I'm Jack Winnett Corrigan on behalf of Summit County Children's Services. Your Honors, there is no rule or statute, etc., that says that this very thing that happened in this case cannot happen. And essentially what Mother is asking this court to do right now is to essentially rewrite Ohio law in a way that the legislature has not provided. So, and Your Honors, you're absolutely right. There are lots of parents who voluntarily relinquish their parental rights even though the other parent is not doing so, and nothing in the law prohibits that or prevents that. So it can be a thing for one parent to surrender their parental rights, and that's what that's what happened in this case. And Judge Carr, at about the same time that you were asking what happens if a parent dies, I was having the same thought, because this is exactly the effect that happens if one parent were to die. The child still had 2 parents at birth. That does not bastardize the child. It merely is that one parent is no longer in the picture and is no longer a party to the case concerning that child's abuse, neglect, and dependency, and the disposition of that child.
Well, counsel, if one parent dies, the child can still inherit from the family. There's still a familial legal tie, right? That wouldn't, if the parental rights were terminated, that would not be the case.
That is correct, but there's, and I think this is starting to touch on one of the points I wanted to make, and that is that because a waiver is a relinquishment of parental rights is, we view 2 things in this situation. We have to determine what is the scope of the parent's waiver. Okay, does it include permanent custody? Does it include relinquishment of the parental rights, which happened in this case? There is nothing in this record, in the written waiver or in the colloquy, to indicate that this mom said, I'm only surrendering my parental rights if dad has his removed. Nothing in that record. And so that's the scope of this mother's relinquishment of her parental rights. And then the second question is, did mother knowingly, voluntarily, and intelligently do that? It has been conceded today that she did, and everything in the colloquy with the trial court indicates that she did, and she even said that she was giving up her parental rights because she believed it was in the best interest of this child. Okay, and she understood, based on the colloquy with the trial court, that by doing this she would no longer have any legal relationship with this child whatsoever. No right to visitation, no right to anything. But my point being is that when we look at whether a relinquishment of parental rights or any other waiver of rights is knowingly, voluntarily, and intelligently entered, we do not consider the collateral consequences of it. If we did that in criminal...
Counsel, but to divest the mother of her parental rights and responsibilities, wouldn't the trial court be required to assign those rights and obligations to another person or entity?
Not necessarily, because the case concerning father was yet pending, because the court granted him a 6-month extension And granted the agency a 6-month extension of its temporary custody. So the agency already had some responsibility for this child during that time. Now, whether father fails and the court eventually orders that the agency will have permanent custody of that child based on father's failure, he still has some parental rights. But again, I'm going to circle back. The validity of mother's waiver of her trial rights and her relinquishment of her parental rights is not affected by the collateral consequences thereof, just like a criminal guilty plea is not, its validity is not affected by any of the over 1,250 collateral consequences that have been identified for entering a guilty plea in a felony case. So the reason why the agency didn't respond to mother's arguments concerning whether she would have an ongoing child support obligation or whether she would have an ongoing right to determine what kind of religious upbringing this child had or any of the other collateral rights that she would have had is because they're non-issues. They're absolutely irrelevant to the question of whether her surrender is valid and voluntary. And I would remind the court to look at some of the case law that is consistent with this conclusion. For instance, this court decided in 2005 that a parent's voluntary relinquishment of their parental rights was not predicated on whether the juvenile court would grant a non-parent, such as a grandparent, whether they would grant that third party's motion for legal custody. So this court has already rejected the idea that an unlimited relinquishment of parental rights, which is what happened here, is somehow conditioned on something else. Now, I will remind the court, however, that we have seen parents who have relinquished their parental rights. That becomes at least part of the clear and convincing evidence that is required under 2151-414 for the juvenile court to grant permanent custody. So it's in that context that we often see in these cases either mother or father relinquishing their parental rights. And could it be a thing for a father, the quintessential deadbeat dad, to come in and say, I don't want to have anything to do with this case. I want to relinquish my parental rights. That is a distinct possibility. There's nothing in the law that prevents that. And I would submit that probably a lot of domestic relations practitioners would love to see that happen on a regular basis when it comes to custody battles between parents. That it would be that they would like to see that more often. So the agency's position is very clearly that this judgment needs to be affirmed as to mother because she did knowingly, voluntarily, and intelligently surrender her parental rights in a way that was non-conditional. And so the severance of her parental rights over this child in the trial court's order was in accordance with the scope of mother's waiver and her relinquishment. And unless the court has further questions for me, the agency would rest on its brief and urge this court to affirm.
Any questions? Thank you, counsel.
Thank you.
You'll have your full 5 minutes.
Thank you. May it please the court. Your Honors, a few years ago, I argued a case here, State versus Anderson, where the trial court imposed a no-contact order on the defendant. And I objected, saying, when he went to prison, I said, there's no authority for that, it's it's illegal. And this court held at that time, well, there's no law against it, so the trial court can impose a no-contact order. That case was appealed to the Ohio Supreme Court, who unanimously reversed and said, the trial court has to act in accordance with the law, not in the absence of law. It's not allowed to do whatever it wants just because there's no law against it. they have to point, when you're doing sentencing, at least in that case, is there a particular aspect of law, then you can do it. And because there's no aspect of a no contact order when you send someone to prison, they said it was unavailable. In this case, juvenile courts are strict statutory courts. They have to follow the law. And the state is admitting there is no law that allows the trial court to do this, but then they say, well, there's no law that says they can't do this. Well, that is my point. If you're going to say that the trial court is acting in accordance with positive law that says they can unilaterally terminate one parent's parental rights, what is that statute? What is that rule? What is that case law? Where does it allow the trial court to do that? And there is zero law. Now, again, if this court upholds this trial court's decision, that would be a shame for this case, but as the parade of horribles I am arguing the state is not conceding, any parent at any time can come into any juvenile court case and terminate his or her parental rights regardless of their obligations in creating that child. I think that's a horrible, parade of horribles. That would be horrendous if this court would sanction and allow that conduct. I already told you, I have numerous men who come to me all the time and say, I am done, I don't want to, I barely know the mother, I don't want anything to do with this child, I don't want children's services, I don't want to be involved. So, I have my own children, or I have other children, or I have other assets, I have money, but I don't want to be paying child support. So can't they just sign over my parental rights? Again, this court sanctions this case. The answer, instead of being that's not a thing, it is a thing. And you can do that. So I think the court should be very careful in drafting a decision saying that no problem here if the trial court can, and again, what permanent custody did the court grant? It wasn't CSB's motion, and what findings did the court make to terminate mom's parental rights? There were none made. She didn't make any best interest finding, she didn't make any statutory findings, it just said it's terminated. So again, the court did it ultra vires, if I'm saying that right. It's beyond the authority of the court. So, respectfully, Your Honor, I'd ask the court to reverse and remand. Thank you.
Thank you, counsel. Thank you both for your presentations today. We will take the arguments under advisement.